Everybody that is joining in. I am Dietlyn Becker from Remax Panache, and today I'm chatting to Neil Knight from Tate Nolan and Knight Attorneys.
Morning.
And we are at Suburban Cafe in Ennisdale Drive in Durban North. So thank you to all of you that are joining along the way. We are just going to get started. There's a couple of people already online here. So Neil, you and I have worked together quite a bit over the years.
Yep.
Through property transfers and conveyancing, and lately we've done a lot of estate work and property transfers for estates.
Yes.
So it's been quite an interesting time of late.
We've had a journey,
yes.
and yeah, estates certainly is a bit of a growth industry at the moment. Sadly, I think COVID obviously had a devastating effect, and so we're finding more and more property transfers are being coloured by having to deal with an estate.
With an estate, yeah. So with the Queen's Jubilee that obviously, the Jubilee that happened earlier in the year, and then now we've just had her funeral yesterday, and I was chatting to people over the weekend, I thought it would be quite apt for us to discuss estate planning today and how that affects property transfers. Because obviously my game is the properties, and you do everything because you're a lawyer that does everything in your company.
Our speciality is conveyancing first and foremost, then deceased estates and estate planning.
Okay, so, perfect. So just briefly, can you discuss what is a will?
Okay, in South Africa there's two ways that you can die in terms of your estate. One is with a will and one is without a will. A will is a document, it's got a series of formalities that are required, but basically it enables you to leave your assets to who you want, and very importantly to choose the executor that you want, because more and more, as we're finding the government departments are failing, you're needing an executor that has a skill in dealing with the issues that are cropping up. We've got a third world infrastructure, and we've got clients that are expecting first world performance.
Yes.
And so for us, even in the conveyancing space, more and more we're navigating dealing with that rather than just simply doing the traditional job. But if you don't get that right, the job doesn't get done.
Okay, so will is basically somebody leaves something to somebody when they die.
Yes.
And if they don't have a will?
Then they die according to something called intestate succession, and there's a special act of parliament that deals with that, and it's got a formula as to where the assets go.
Okay.
A lot of people are afraid that if they die without a will, their money will go to the state. It doesn't, simply doesn't.
Okay.
It just makes it more clumsy to wind up, but there's not really too much difference between the two. Always better to have a will because you can choose where you want to leave your assets, and also, as I say, you get to choose who's going to be administering that estate for you in the 2 or 3 years it might take to wind up after you die.
So that's the executor then that you choose?
Yes.
Okay, so who is an executor normally then?
Okay, very often a spouse might be nominated as an executor, or a child. 99 times out of 100 they won't be able to do the job. It is very technical, and as I said, it can be a minefield dealing with the relevant government departments. So the practical solution is that either an attorney or an accountant is appointed, but it must be one that specializes in deceased estates. All attorneys can wind up estates, but not all attorneys know how to wind up estates.
Okay.
The banks are generally a very bad idea.
Yes, I've heard that.
For them, it's a profit center.
Yes.
And quite frankly, your family is not being treated as it should be when you're bereaved.
So essentially, you should be choosing somebody who you know and trust.
Yes.
That can obviously carry out your wishes for your family.
Yes.
What happens if? And this is what is the Guardians Fund? Because this is what I wanted to ask you, and we discussed briefly earlier. In that my gran actually way back when left money to my sister and myself, and it was left in the Guardians Fund, which we did get out when we were 18. But what is the Guardians Fund, and how does that work?
So there's a law in South Africa that says that a minor cannot be given his or her inheritance. Simply, you're not a major, so you're not allowed to get hold of that money. So when we do a will, we often create a trust in that will. It's called a will trust, which is only activated if somebody is inheriting who's under the age of 18 or 25, whatever you choose. And then the family can look after that person's money. If you don't do that, or if you die without a will, intestate. Then what happens is the only place where the executor can put that minor's money is into the guardian's fund.
Which is probably what happened with me.
Yes,
Okay.
and you probably find your grand didn't die without a will, or died without a will or something.
Yeah.
But the guardian's fund is a state-administered fund. It's clumsy. I don't think the interest rate is particularly good. We'd far rather have your money being looked after by a family member, together with a trusted professional, maybe an accountant or an attorney, to look after the interests of the minor. Don't forget as well that the money is to go to the minor when they turn 25 or whatever age is chosen, but it's also to look after them whilst they're growing up.
Yes.
So school fees, perhaps an overseas trip, perhaps a first motor car.
Okay.
Now I think trying to get that out of the guardian's fund will be impossible,
Yes.
whereas if you've got a couple of trustees that are looking after the minor's best interests, their job is really to balance giving as much as reasonably possible to the minor while they're still a minor, and then having a pot to give to them at the end of the day.
At the end of it all.
Yeah.
So again, going back to the fact that choose somebody that you know and trust
Yes.
to handle it as the executor,
Very-
and the trustees.
Yes, very often it's a good idea to appoint your executor as your trustee and a family member that you trust. So
Okay.
somebody can put the professional side in, and somebody can put the soft touches in. For example, it might be the dying person's wish that their son goes to Kersney, and the family member would know that and would push for that, whereas the executor might be tempted to say that's a bit expensive, bearing in mind how much money we've got, and the two of them discuss it and they come to something which is actually in the best interest of the person, the minor. Yeah.
Okay. And then something that we touched on briefly as well is a power of attorney. Because some people, and I think we have had this in one of our property transfers,
Yeah.
where somebody did a power of attorney just before they passed on, and then the person automatically assumes that they can sign away on the bank accounts, etc., and then they will be the nominated executor, and they just carry on trading. But that's
Okay.
you can't do that. What is a power of attorney?
Technically, no. Okay, you won't believe how often this crops up. In South Africa, you don't get something called an enduring power of attorney. So if you give somebody power of attorney to look after your affairs, that power of attorney only lasts for as long as you've got the mental capacity to continue to want to give it. So if you develop Alzheimer's or dementia, if you have a stroke and you're unable to form thoughts, that power of attorney lapses no matter what you want. Okay, the problem with that is, in South African law, you're only left with one other option, which is to apply to the High Court to have a curator appointed.
Okay.
Very clumsy, very expensive, and most of the times the person ends up dying before the curatorship process has even been sorted out.
Okay.
So it is a big anomaly in our law. Generally what people tend to do is that they will have, for example, their aging mother give them a power of attorney, and whilst things are fine, it's fine, what they tend to do is go a little bit quiet when the deterioration starts, and they manage it informally on behalf of that mother. But if the bank, for example, were to find out, they would immediately cancel the power of attorney.
Okay.
Another very important point with the power of attorney is the general power of attorney isn't accepted by everybody.
Banks, yes.
And the banks themselves want to see the child and the mother, and they want to ensure that the child isn't pinching the mother's money. So they will only give a power of attorney if they're happy that mom is in a sound and sober senses, and they will then do all the documents on their paperwork, and then that child can have access to the bank account. Obviously, the biggest risk is somebody stealing the mother's money and fights amongst the family.
Okay, because that's what I was going to ask you, is the banks have got a very different power of attorney to just a general power of attorney, and I have heard where people have had to take their parent into the bank and they ask questions and obviously get to sign.
My dad died, and so we had to take my mom into Nedbank to sort out her power of attorney. It was about a 3-hour exercise. Myself, my brother, and my mom had to be there, and we were literally grilled. And it was 3 different managers that came to speak to us. So the banks take that obligation very, very seriously.
Yes,
which
because
is a good
essentially
thing.
they're signing over to you and your brother
Yes.
the operation of her bank account.
And we could steal all of her money if we chose to.
If
So
you chose to,
they've
which
got to
hopefully
be.
you didn't.
No.
No, definitely not. And then just touching back on the curatorship that you spoke about earlier, I had an incident where I actually called you with those clients the one day, and
Yes.
They were married in community of property,
Yeah.
and we'll go back to just now, and she wanted to apply for a bond.
Yes.
But obviously in community of property you have to apply for both people to apply for the bond, and both parties' names have to go on there. And then you actually told us at that point about curatorship that she couldn't do anything. She couldn't apply for a bond and purchase a house.
Yeah.
So that's where we had to look at alternatives of her purchasing in her son's name. But that was the first time I learned about curatorship and how it affects marriage systems.
Yeah, it's a very, very real problem. Remember that if people are married in community of property, they're co-owners of their estate. So one cannot sign anything without the other one. So generally, community of property is not recommended. I've been a notary for a long time, and in 30 odd years, I've never come across a situation where I gave somebody advice to be married in community of property. Okay, so generally it's antenuptial with or without accrual. Generally for younger people, ANC with accrual is better, and most often, or very often for older people that perhaps have separate families that they want to keep separate, ANC without accrual tends to work. So people getting married later on in life tend to choose that, but not always.
Okay, all right.
Okay, there's no difference really between the ANC with or without accrual in terms of credit risk and things like that. That's what a lot of people often assume, is that the ANC with accrual is a bit like community of property, and suddenly your assets will be attacked potentially by creditors. Not the case whatsoever. And
then with an ANC with accrual, somebody can purchase a property on their own without their spouse's consent.
100%, because it's an antenuptial contract.
Okay, all right. And then obviously when they sign the contract, they should be signing their will and updating their will at the same time to make sure that all parties are happy.
Yes, always a good idea. Wills are not so critical if there's a couple that's just being married and they haven't really started out in life yet. It's quite simple. If one of them dies, it'll all go to the surviving spouse. But when there's children, it becomes absolutely critical.
Okay, and then the ANC without accrual at later point in life, then it is important to then update the will and make sure everybody's happy and everybody's going to be covered where they all want them to be.
Yes. Remember with accrual, the accrual is calculated when the marriage ends. So if somebody dies under accrual, they get their accrual first, and then the deceased person's will comes into effect. So normally, with a husband and wife, you leave everything to your spouse, and if that spouse dies, the surviving spouse will normally get half of the estate by virtue of the accrual, and the other half by virtue of the will. So the will is a very important tool in making sure that your spouse and or your children are looked after.
Yes, and then that also was one of my questions that I wanted to ask in terms of the will and spouses. If you have your spouse that you want her to stay on in the house, or you want him to stay on in the house when you die, can you specify that in the will for a specific time frame?
Yes. Okay, that's called a usufruct, and they used to be very common. They're not so common anymore, but if it's appropriate, it's a good idea to do it. And basically what it does is it allows the surviving spouse to stay in the house normally until their death. Very often what happens is at some point they have to move out because it's inevitably not an old age home, and then the usufruct lapses. But usufruct is fairly common. You need to take advice because there's a couple of different ways of doing it, but we can help with that. Okay.
Perfect. And then one last thing, you did mention about being a notary and a notary public. What is the difference there between a notary and an attorney? Quickly.
Okay, so basically a notary public, you're like a super commissioner of oaths. You have to write a separate exam. And in the old days it was important because you used to have bills of protest and all sorts of funny, weird and wonderful things, and mineral rights where the notary was a very important person. Bottom line is at the moment the notary's main job is to be involved in sectional title work a little bit in the deeds office and antenuptial contracts.
Okay, so then if somebody's overseas and they have to sign documents, do they do that in front of a notary public?
Yes.
Or,
okay, there's a whole set of rules for that as well. Most of the countries in the world have signed, belong to something called the Hague Convention. And in terms of the Hague Convention, well, just imagine every country might have different requirements for somebody to be qualified as a notary. So a notary, for example, in Nigeria might not have the same ethical standards as a notary in, say, the UK. So what these countries of the world did is they formed this convention, and they've accepted that, for example, that a Nigerian notary is acceptable to the United Kingdom authorities. So if he certifies something, they take it as valid. The only problem with that is it becomes an expensive process to have something valid, because so somebody could go to that Nigerian notary and have their documents certified, and it'll be fine for use in Nigeria. But if they want to use it, say, in England, what they would need to do is have that notary's signature validated by the courts in Nigeria, and this is done by something called an apostille. And what happens is Basically what it is the court certifying that that guy qualifies as a notary in terms of the Hague Convention, which means that the guys in England will treat it as if it was done by an English notary. Only problem, of course, is that it becomes expensive to do that.
And that's why everybody runs around getting their birth certificates or their children's birth certificates apostille for passports, etc.
100%. That's for use overseas.
That's for use overseas. Okay, and then just quickly, so digital signatures of documents and signing documents and property documents overseas.
That's a very vague area. The world is moving towards digital signatures, but for example, we've still got very real issues, like the deeds office. You need to have wet ink, as far as I'm concerned. Technically, you're not allowed to do a Zoom meeting with someone overseas and certify their affidavit. You're supposed to go the apostille route. I know a lot of people do it, and it's probably moving that way, but at the moment we're in a state of flux. Generally, for important documents, for a will, for example, I don't believe that you can do it by way of electronic signature, and if you do, you might have a problem to get it accepted by the master. It might involve an application to court, which you don't want to do, so rather just use wet ink. So
basically for now in South Africa, for all the important documents, still just use wet ink, sign it, scan it to email, send it on to everybody, and then the original must be sent to somebody and kept in safe keeping. Okay,
I've got a few thoughts on that. A will, the master needs to see the original will, so you need to make sure the original is safe somewhere. And a big problem when somebody dies is the family sits and says, where's the will? And if they don't know where it is, that's a huge problem. So normally what we do is we keep the original will with us, and we give 2 copies to the testator, and we ask them to give one to a special person, for example, the insurance broker or one of their children, so that if somebody dies, they can say, oh, here's the will, they've got contact details on, and then we can start the process.
And then you can start the process at that stage. Okay, sure. So it's very complicated.
That's only starting.
And then, and then obviously we haven't even discussed talking about heirs, but that I think is a whole nother story for another day.
Another coffee date.
Another coffee time, definitely. But thank you very, very much. Pleasure, I really have enjoyed working with you over the years. And certainly these estate ones that we've been doing of late have been rather challenging, but enjoyable still, and learning a lot. So hopefully I've managed to impart a little bit of knowledge to everybody this morning on estate planning and wills. And quite lucky for them in England that they don't have to worry about their wills in terms of the new king and everybody. They all just gets passed down the line. They know exactly up front who's going where.
Who's getting what,
but we have to make sure everything's in writing, all the T's are crossed and I's are dotted.
And a big thing in England, the default if you get married is to be married out of community of property, so you don't do an antenuptial necessarily there. In South Africa, you need to do an antenuptial to contract out of community of property. So in England, they don't bother about it. Here, if you don't do that, you're married in community. And as I said, I've never come across a good situation to be married in community
of property. So, which also, just quickly, on our last question, so that's actually quite an interesting one. So if somebody gets married over there and then they come here and purchase property, then how does that work quickly?
Very easy. The law of the husband's domicile at the time of the marriage governs which law governs the marriage. So if, for example, somebody in South Africa, a couple go overseas and have a holiday and get married, and they don't do an ANC, they're married by South African law because at the time the husband regarded South Africa as his permanent home, and they're married in community even though they were married in England. If, for example, flip it around, the couple's living in England and they pop out to see their family and they get married, the husband's permanent home at the time was London, they're married according to British law, despite the fact that they were married in South Africa.
Oh, wow.
So it's the law of the husband's domicile at the time of the marriage.
Okay, all right. Okay. So husbands, again, the whole patriarchy, but we won't even go there.
Don't even try.
Don't even start that one. No. But thank you so much, Neil Knight from Tate Nolan Knight Attorneys here in Durban North, doing estate planning, conveyancing, which is how we got to meet first of all those years ago. And if you've got any questions, please pop them through on Instagram, on my WhatsApp. You can always email Neil as well. I'll pop through all the details on that later on. It's will month, so just update your will and have a look at everything and give Neil a call if you need to. Thanks so much.
Thank you, Dietz, very, very much.
Okay, thanks so much, everyone. See you next Tuesday.
Bye.
Bye.